What is a will? A pretty basic question, right? Everyone knows what a will is, but why do we need one? You'll find out all of that and more in this episode of Estate Planning Essentials. Hey everyone, welcome to Estate Planning Essentials. I'm Kristen, Product Specialist at WealthCounsel. On this channel, we supply tips and information on document drafting and estate planning. So if you're a newcomer, please consider subscribing to the channel. And hey, at any point during the video, check out our show notes and links in the description below. Today, we'll be covering wills and pour-over wills, where we'll get into what a will is, the reasons for having one, and the difference between wills and pour-over wills. So let's get started. A will is a legal document that becomes effective only when someone dies. Until that point, the will can be changed at any time. The person who makes a will is called a testator if a man, or a testatrix if a woman. When a person dies with a will in place, it is known as dying testate. A person who dies without a will is considered to have died intestate. When somebody dies intestate, the laws of the state in which he or she resided at the time of death will determine how the person's assets are to be distributed. These laws may or may not mirror how the individual would have liked for his or her assets to be distributed, which is why it's always better to have a will. Serve two very important purposes. The first reason for having a will is that it allows individuals to leave their assets to whom they want in the way they want when they die. This means assets can be left outright, in which case a beneficiary would receive the assets immediately when the individual dies, or they can be left in trust, where the individual making the will can spell out how and when the assets are to be distributed to the ultimate beneficiary from the trust. If a trust is created under a will, it's known as a testamentary trust, and it's established upon the death of the individual. The second reason for having a will is that this is the document where an individual can nominate legal guardians to care for his or her children if the children are minors when the individual passes away. Even if someone does not have any assets to plan for, nominating guardians is one of the most important reasons that a parent would still need to have a will. Sometimes people will ask what the difference is between a will and a pour-over will. A pour-over will is generally drawn up when an individual has a revocable living trust in place. While you can learn more about revocable living trusts later, just know that these are trusts created during the individual's lifetime to hold assets in a manner that allows for them to avoid probate and be effectively managed during periods of incapacity. The instrument which governs the revocable living trust also sets forth how the trust assets are to be distributed upon the individual's death. A pour-over will generally provides that any assets which were left out of the trust during the individual's lifetime are to be contributed or poured over into the revocable living trust upon the individual's death. The assets are then distributed according to the terms of the trust. The pour-over will also nominates guardians for minor children. Even if an individual has a revocable living trust, they should still have a pour-over will in place. Pour-over wills differ from more traditional wills in that pour-over wills typically do not provide for how assets are to be distributed upon the individual's death, other than to have them all be distributed to the revocable living trust. Thanks for checking out this video. Please make sure to like and subscribe to see more videos like it. If you would like more information about wills and pour-over wills, you can always access that right here, or check out the show notes and links in the description below. See you next time.